doesn't take in consideration the atrocity of the tragedy, killing six person and injuring five of them. Our deep concern is about the orphans that will see the murdering person in the road of Quebec City 25 years after this tragedy.
Reaction from Mohamed Labidi, president of the Islamic Cultural Center of Quebec. Reaction on Friday. Now, of course, on Friday morning, we learned that Canada's highest court declared a 2011 criminal code provision that allows a judge, in the event of multiple murders, to impose a life sentence and then parole eligibility periods of 25 years to be served consecutively, right? So Supreme Court ruled that criminal code provision unconstitutional. What it means is that Alexandre Bissonnette can apply for parole now after 25 years. Let's go to Ari Goldkind, criminal defense lawyer and legal analyst. Ari, welcome back to the show.
Great to be on with you, Elias.
So first things first, let's actually get to the initial sentencing, because I've been seeing a lot of bad headlines. I've been seeing a lot of headlines that don't get what actually happened here. Alexandre Bissonnette was sentenced to life, right? That was his sentence. Can we go to the original sentence, what the judge at the time had determined, and take us through how it all played out?
The original sentence was life. It's never changed. It's always life, always going to be life. But the parole ineligibility period was the issue. The original judge made it a 40-year parole ineligibility period. He sort of tinkered with the law as he understood it. Then it went to the Court of Appeal. The Court of Appeal said it's cruel and unusual to let somebody die in jail without a chance of breathing the same air as you and I. That, because it's a matter of national importance, went to the Supreme Court. And in what I consider still a shocking unanimous decision, the Supreme Court agreed with the Quebec Court of Appeal and said as follows: it's cruel and unusual that somebody like Bissonnette, a guy who shoots up a mosque, an Alec Manasseh, a guy who mows down innocent civilians on Yonge Street in Toronto, it's cruel and unusual that they don't get to apply for parole, and it's an affront to their dignity that they might die in jail without a chance of breathing air. That's, I think, what the gentleman that you played the quote from is properly responding to, and I can assure you, even as a criminal lawyer, I have a lot of problems with this decision.
Well, this is why I wanted to talk to you, right? Because you are a criminal defense attorney, right? Yeah. So you would think, right, that you know what, you're gonna be on the side of 25 years, absolutely they should get parole after 25 years. So why you're surprised here, Ari, that the Supreme Court of Canada went with its ruling?
So let me start by saying, as a criminal defense lawyer, I'd walk into court, and if I was retained by somebody, I would say probably the opposite of what I'm saying to you. But I also am a Canadian citizen. I'm a political commentator, and I have my own opinions. So it's important that your audience understand, in the day and age of tribalism and your team versus my team, this was a law in 2011 that the Harper government put in. Harper, who has become like Voldemort, you're not allowed to say his name, said, look, you don't get a freebie or a pass or a get one free when you kill more than one person. Each life has to matter. Each life in the criminal code has value. Each life morally has value. You don't get to do 3, 4, or 5 and have them all count towards one for parole ineligibility. Here's why I say that, Elias. Because the Trudeau government, who doesn't like anything about Harper or Voldemort and changes everything he wanted to do and has a different vision for the country, the Trudeau government also thought this was a good law. So you got to remember, this is a parliament in a democracy where two vastly different political groups, arguably, both thought this was constitutional. Simply saying something not controversial, which is, look, if you kill 10 people, if you blow up a plane, if you mow down Yonge Street, you may, unfortunately, due to your own actions, not be somebody that will breathe the same air as you and I. The Supreme Court says, no, you can never take away rehabilitation. You never want to throw away a key on somebody. You never want to view them as unrehabilitatable, unrepentable. And I accept that. I accept that maybe Mr. Bissonnette could see the error of his ways. I don't accept that, really, but I do, okay? The problem is that the Supreme Court, through about 140 pages, it's very long, I don't remember the exact number when I read it on Friday, spends no time talking about the victims, the families, the loved ones, the actual dead people who I think are 6 feet under rolling in their grave or in heaven looking down on this decision and going, why do we not matter? And you remember how you said, Elias, I'm a criminal defense lawyer, so you'd expect me to come in here and defend it and say it's fantastic, right? Mm-hmm. My view is my obsession as a criminal defense lawyer is to make sure nobody innocent gets convicted of a crime they didn't do. That's why I have such concerns with the Me Too movement, this believe all people stuff. As a criminal defense lawyer, I find anything where we presume people guilty, where Twitter carries the day, that's abhorrent to me. But once a jury or a man himself pleads guilty and says, I've killed a number of lives, I don't know. I don't find it so cruel and unusual or unconstitutional or contrary to the democratic will of Parliament that 9 judges who probably have never experienced the kind of pain that murder victims and their families have felt come and in an intellectual exercise, which, look, I respect. I've read the decision. In some ways it makes sense to me. In other ways it doesn't. Mm-hmm. But it really, really concerns me that the entire thing is about the offender and the murderer, even though the Supreme Court says, look, between you and me, Canada, they're never going to be released. The parole board will never let them out. Well, this is a tempest in a teapot. I don't really accept that reasoning.
Well, so Ari, I do want to get to that, right? We're with Ari Goldkind, criminal defense lawyer, legal analyst. So I want to get to that whole notion, right? Because, if it's really a life sentence, right? So what we're talking about here is the first time someone can apply for parole. You mentioned before the previous judge had tried to tinker with the law and did halvesies, basically. Okay, not 25, not 50. Let me do 40, so he has a little tiny chance of being 70 years old and getting out, right? So to that, Ari, he's never getting out. So
he's never getting out. But here's the way I look at it, Elias, which I don't think I've read or seen a lot of people talk about. 2 points. One, the Supreme Court comes and says, well, it's unconstitutional that he doesn't get to apply after 25. Well, what's magic about that 25 number? Where'd that 25 number come from?
Yeah, it's a round number. It's because it's a nice round number.
But my point is, that's as arbitrary as anything else. Why wouldn't the number for first-degree murder be 40 years? Okay, and if you're a 50-year-old killer, is a 40-year parole ineligibility period unconstitutional? There's some intellectual gymnastics going on here, Elias, that make me deeply uncomfortable as a person who tends to think morality has to be the backbone of the criminal code. It has to be. But here's the second point, which I don't think is talked about enough. I've said to you, and the Supreme Court does say this at the end of their decision. Your audience can go read it themselves. Don't worry, the parole board's on it. They're going to know it's vicious. They're not going to let the guy out, okay? I'm paraphrasing. Yeah. But here's the problem. You know the name Paul Bernardo, Elias, right? Mm-hmm. We know he's never getting out. But now that he's at his 25-year mark, he keeps having these parole hearings. And what ends up happening? The French and the Mahaffey families, the victims of those he killed, keep having to drive to a penitentiary and go through this. And my question is, at what point is there an act so hideous, so evil, so unrepentable, even if the person themselves may be rehabilitated? Theoretically, they've seen the light. They found Jesus. At what point is it unconstitutional in a Canadian democratic society for our parliament, our elected representatives to say, you do something so egregious, you blow a plane up over the air, okay, in Canada. You drive down a main street, St. Catherine, I'm trying to be Montrealish, St. Denis, and you kill 25 people purposefully. Mm-hmm. Purposefully. You're not mentally ill. You're not out of your mind. You do it purposefully. At what point as a society do we say, for the 10 to 20 people every 10 years that do that, maybe, just maybe, we separate you from society? The Supreme Court then says, well, we don't want to have people in jail who have no hope, nothing to live for. They may be violent. They may slash other people. They may go after guards. If that's the reason to do it so that jails don't turn into San Quentin, okay, build San Quentin in the Yukon and keep it. I just think there's got to be something that we agree is so horrible that you just don't get the same air as you and I.
So, Ari, I need to wrap up, but I want to get your take on this last question then. For the federal government, right? Should their view now be, okay, we're going to have another a kick at the can. We're going to come up with a new criminal code provision that gives judges the ability to go 30 years, 35, 40, not in like increments of 25. Should they have another kick at the can with legislation, or should they simply invoke the notwithstanding clause on the ruling?
The notwithstanding clause won't work because it can't stay open forever. The notwithstanding clause is sort of on a time clock, sort of like the Jeopardy countdown, or when the buzzer goes off on Wheel of Fortune. It can't be used in perpetuity. Anybody who tells you it can, I think is wrong. I thought Pierre Poilievre tried to put that out into the universe, and I just, as a lawyer, I can tell you the notwithstanding clause is not some endless clause. So to be quick to your question, that's not going to work. Here's what I think. The Supreme Court has left the bait there for Parliament. Lametti says he'll look at it. There's very little you can do because any parole ineligibility period, if they'd increase it to 35 or 40, so long as it takes a person up to the relative ballpark of the end of their natural life, the Supreme Court is going to call that cruel and unusual, disproportionate, and indignity. So I think at the end of the day, any tweaking or all of that stuff is not likely to bear the kind of fruit that the victims of the Mosque Massacre or the Manassian Massacre or many other murders, at least 10 to 20 in Canada, are going to look at. So I think some tinkering may be looked at, but I think the Supreme Court will shoot it down if it keeps somebody in there until their 60s, 70s, or 80s.
Ari Goldkind, criminal defense lawyer and legal analyst. Always a pleasure getting your insight. Thanks so much.
Thank you, Eli.